Okay, greetings. This is going to be a lecture on legal reasoning. This is actually the third time I'm trying to record this lecture, and the first time I recorded it, and I thought it went fine, and then when I played it back, the audio was very distorted, and I'm thinking, oh, that didn't turn out very well. So then I re-recorded it, and the audio came out fine, but it was just a very impaired. Well, impaired is the wrong word, but it wasn't a very polished presentation. I kept stumbling over things. I was distracted. People kept coming into my office, and I had to keep pausing the recording. So in any event, we're hoping that the third time is the charm, and that this will be an even better, more useful presentation of my notes on legal reasoning. Now, as often is the case, my PowerPoint and my lecture is really just a re-presentation of my lecture notes. And sometimes that drives students nuts because they're going, oh, this is just the notes. He's just reading his notes. And that's kind of the case, right? And I acknowledge that. So if my notes are sufficient for you and you don't need any additional guidance, you kind of get what I'm saying there, and that's fine. This lecture may not be necessary for you. Maybe you understand a lot, but there's just particular areas that you're a little fuzzy on, or you'd like a little more clarity there. You might want to actually go and see what I had to say in the lecture. And then, some of you actually might find some of the things I'm saying as I'm discussing it in a more conversational way to be helpful. So that's the plan, at least, right? That you will find some value in this lecture, or at least some of you will find some value in some of this lecture, right? Can you imagine if no one finds any value in any portion of this lecture? What a colossal waste of time this would be. But c'est la vie. All right, so let me share my screen. Here we go. Share. And as I said, this is legal reasoning. Now, this is the final module that we're doing in my critical thinking class. One of the things I was sort of happy to see is that many of the topics I touch upon in this legal reasoning echo things we've discussed earlier in the class. Things like analogical reasoning and deductive reasoning, things like essentialism and necessary and sufficient conditions, and conjunctions and disjunctions and this sort of thing. So this module actually will trade upon and utilize a lot of the concepts that I think we've already introduced, and hopefully some of which you're already familiar with. So in a sense, it really is a culmination of the rest of the course. So I'd like to say I did that on purpose, and yes, I did. I did that on purpose. Why is this not working? There we go. So we're going to begin with an overview. So when we're asked to think about arguments and critical thinking, our first image that might come to mind would be that of attorneys in court and arguing their cases in court. Argument and logical reasoning is clearly indispensable for the practice of law. In court cases, lawyers are successful, in large part, to the extent that they can produce convincing evidence and argument in support of the conclusion they would like the judge or the jury to believe. This will require the use of logical reasoning, as well as the use of rhetorical devices and persuasive techniques. But in fact, many cases have been decided on the basis of bad argument accompanied by powerful rhetorical techniques. And so you want to develop both, but hopefully you have an arsenal of very strong arguments on your side. There are many varieties of law: administrative law, commercial, criminal, international, tax, contract law, family law, etc. So much so that one might therefore think that there is no distinctive common activity that one might call uniquely legal reasoning. And there's a sense in which that's correct. However, we can distinguish additional reasoning skills applicable to most, if not all, of the aforementioned types of laws. And so that's what we'll be covering in this presentation. First, we must note that in deciding legal cases, we have to determine what the law is. Now, law comes to us, and we're going to be dealing with that question for the first couple of these segments now. What do we mean when we say, what is the law? What is the nature of the law? What is the law, etc. So first, we want to distinguish where the two varieties of law that we deal with in our contemporary society. Strictly speaking, we have two distinct sources of law, what is called case law and what is statutory law. And identifying and applying these two different sorts of law actually require distinct rational skills. So as we shall see, case law turns a lot on reasoning by analogy, whereas statutory law turns largely upon deductive reasoning and the application of general rules. So what is the difference between case law and statutory law? Well, case law, which is also referred to as common law, and I kind of go back and forth at times, so I'll try to say case law all the time, but if you see common law, you know I mean the same thing. Case law is law that has been established by previous precedent cases. Prior judicial decisions are used to guide the resolution of a new legal case rather than specific statutes or regulations. So here we decide we have a new case that's brought to us, and what both sides are going to argue is that given precedent, given past cases, the right way to judge this case is A or not A, whichever side you're arguing, right? And so you're going to stack up those examples of precedent cases which hope to establish your claim that the appropriate way to decide this new case and the way most consistent with existing precedent is in the way that you're arguing. Now, we shall see the application of case law turns largely upon inductive reasoning by analogy, i.e. that like cases be decided alike. In contrast, statutory law are laws written and or passed by legislatures in federal or state governments or approved regulatory bodies and adopted by society. The application of statutory law often takes on the character of deductive reasoning, the application of a general rule under a general principle under a common rule. So for instance, we might have an existing statute that says no non-citizen is allowed to vote in a federal election. John Smith is a non-citizen, then it would follow that John Smith is not allowed to vote in this November's election, federal election. Right? So this would be an example then of a general rule, a particular instance, and simply applying the rule to this particular instance. I'm not citing individual cases from the past. I'm simply citing the statute and showing how the facts of this case bring it under the governance of this particular statute. Case law originally developed in England over 1,000 years ago with its reliance on precedent as the determining factor for current decisions. Its logical basis is the principle of treating similar cases similarly. And I think I say this in a note, and I'll mention it here. There's a subtle difference between finding two cases to be the same and finding two cases to be analogous. And there is a distinction within the practice of case law between these two things. We don't need to worry about that for the purposes of these notes. So I'm just going to talk about analogous cases rather than cases literally being the same. There are even legal disputes as to whether it's ever the case that two cases are the same. So that's why I feel I'm on safe ground here. Case law legal systems are distinguished from civil or statutory law legal systems, where there is greater reliance on statutory enactments as typified by ancient Roman law. So our modern legal system makes a use of a combination of both of these. So our emphasis on case law is an influence of the English legal tradition, and our emphasis on civil and statutory law is an influence from the Roman law, the ancient Roman law tradition. Case law and appeal to precedent. The kind of argument that occupies a special place in the applying case law is appeal to precedent. In the notes on ethical reasoning, that module, we acknowledge the rational requirement that like cases be decided alike. Seems simply to be a principle of rationality, right? And where two cases are decided differently, we must state what the ethically relevant difference is between the two for deciding differently, right? So if I'm going to say, oh, in your case, what you did was moral, but in your case, Bill, what you did is moral, but in your case, Jose, what you did was immoral. Well, why am I deciding differently? I have to tell you what the morally relevant difference is between what Bill did and what Jose did, right? Again, it seems to be a principle of rationality. It seems to be a principle of ethical reasoning as well. There is in legal reasoning, earlier cases stand as a precedent, and we must either conform to that precedent in the current case, or point out how the current case is in fact importantly disanalogous to the previous case, or explain why the initial case was decided incorrectly in the first place. So essentially, we're doing in case law what we already do, or what we've already talked about doing in ethical reasoning, like cases be decided alike. And so if I say, oh, we have to decide these two cases differently, then I have to say, well, they're not really the same, right? There's an important difference. Or we have to say that the case was decided wrong in the first place, which why it was wrong then, and it would be wrong to do that now. Or we have to consent that that the cases are analogous and we should be deciding them the same. This is the practice of using case law that has already been decided as an authoritative guide in deciding a new case that is similar. Appeal to precedent is an instance of arguing by analogy in which the current case is argued to be sufficiently analogous to the previous case to warrant deciding it the same way. Appeal to precedent presumes that logical consistency must be maintained as we build our edifice of legal knowledge. And again, you may want to revisit the notes on coherence theory of truth, which is in the notes on logical positivism, way back in that module on logical positivism. At the end of the notes, I talk about different conceptions of what it means to judge correctly or to judge truly. And one would be the coherence theory of truth. The correct theory is whatever judgment is most coherent with existing body of beliefs. In ethical reasoning, cases that are relevantly similar must be treated the same way. To treat similar cases differently would be illogical and unethical. In law, we would further deem such actions as unjust. Now, of course, the task then becomes to determine whether the two cases under consideration are relevantly similar, and that means determining what the facts of the case are pertinent to the law or to the principle at issue. Case law and appeal to precedent, also referred to as stare decisis. The Latin name for the principle of an appeal to precedent is stare decisis. Stare decisis is the legal principle for determining points in litigation according to precedent. And it refers to something like you don't change settled things, right? You want to stand where you are. According to the Supreme Court, stare decisis is advisable and desirable because, one, it promotes the even-handed, predictable, and consistent development of legal principles. It fosters reliance on judicial decision, and it contributes to the actual and perceived integrity of the judicial process. So here are three presumably virtuous consequences of stare decisis, or appeal to precedent, right? We want our laws to be predictable. We want people to know what the law is and how to act and where the lines are, right? If you want people to stay within the lines, they have to know where the lines are. You want a reliance on judicial decisions, and you want to have a perceived and actual integrity to our body of legal beliefs or legal judgments, etc. Again, a kind of consistency. It should be noted that in practice, the Supreme Court will usually defer to its previous decisions, even if the soundness of those initial decisions is in doubt. The benefit of this rigidity is that a court need not continuously reevaluate the legal underpinnings of past decisions and accepted doctrines. Moreover, proponents of this practice argue that the predictability afforded by the doctrine helps clarify constitutional rights to the public. So again, you're letting the public know what rights they have, what rights they don't have, where the lines are. Again, this contributes to predictability, reliability, etc. Thus, we see within case law reasoning an institutional bias towards maintaining the existing rules. But note, this bias does not in fact presume that the existing case law was just, fair, or even practical. It is a system bias, itself isolated from these other considerations. So, in point of fact, the institutional bias for stare decisis does not take into account whether existing case law is just or fair. Again, whether it was these cases were decided appropriately in the first place or not. In point of fact, despite the institutional bias, case law is resistant to, but far from immune to change. Judges have sometimes made creative use of provisions within the law to avoid a straightforward application of precedent, especially in instances where such an application would result in what they deem to be unfair or undesirable outcomes. So sometimes judges will find creative ways around stare decisis, or deciding to seemingly analogous cases the same. And sometimes there will simply be an overturning of the decision of previous, right? And then that has to be resolved by higher courts. For this sort of legal reasoning, the important question becomes, what are the precedent cases, that should say, and among them, whether there are any, in fact, analogous and so similar to the present case that treating them differently would violate stare decisis. So if you're doing case law, you have to do a lot of research on and know your cases and know the history, right? Sometimes literally going back hundreds of years for precedent cases. Apart from their significance to the parties involved, legal reasoning by analogy is not different in principle from reasoning by analogy in other contexts. Thus, the resolution by case law is based on previous legal judgments made over potentially hundreds of years. In the development of the body of case law or common law, there is an ineliminable requirement of logical consistency and coherence with past judgments. Indeed, it is by this very requirement that the body of case law is built. While statutory laws have statutes as their basis, in case law, most often, a judge refers to similar cases in the past and uses judgments rendered as the basis for deciding the current case. Note also the new case and presumably coherent judgment becomes in effect new precedents, and thus new laws where there were no presiding statutes, further entrenching the decisions of the past. So as case law develops, it further entrenches values from the past because the new precedent, which echoes previous precedents, will further entrench. It becomes another sort of case on that side, right, that can be appealed to in the future. Though they act as statutes, these precedents are formed by judges rather than legislative bodies, judges interpreting the existing law and determining new boundaries and decisions. Thus, case law is always in the process of being developed, refined, and evolved on an everyday basis. Case law develops gradually through the rulings of appellate judges who may in fact have heterogeneous preferences, but are partially bound by stare decisis. The evolution of case law is therefore gradual, predictable as it converges towards more coherent and presumably more efficient sets of legal rules. So my point here is that even judges with different legal philosophies, even judges with different political orientations or sets of values, etc., because they're bound by case law and stare decisis, there is going to be a gradual convergence, even of individuals with different orientations, because they're going to be meeting out the logically coherent dictates of precedent. Statutory law and the deductive application of general rules. Statutory law is the body of laws passed by various legislative bodies or regulatory government agencies of a country. Thus, there are laws passed by federal and state governments, ordinances passed by towns and cities, all having the force and power of law. New laws are issued to meet the needs of the citizens, respond to new challenges and crises, resolve outstanding issues, or to formalize an existing law. So notice some new need might arise because of a change in the environment or because of a change in, I don't know, traffic patterns or something like that. And a need might arise for a new rule to govern this new set of problems. And this is when the legislature might get involved and pass some sort of new rule or statute. The lawmaking process occurs apart from the case law process. Statutory laws are developed by the government of a state or nation, and these organizations, these are organized and codified into law codes. They cover all areas regulated by statutory laws exclusively, as well as those areas where common law is not applicable. Thus, statutory law, that is the law crafted and approved of by legislative or regulatory bodies, strictly speaking, is not inherently constrained by the principles of coherence, analogical reasoning, or stare decisis. So this is a point I want to emphasize here, right? That you have this institutional commitment to stare decisis, coherence, analogical reasoning within case law. You have none of that in statutory law. There is no requirement that state legislatures pass laws which are coherent or consistent with existing case law or even existing other statutes. So this can bring statutory law into conflict with case law, conflicts themselves which must be addressed by the appellate courts. I actually don't say this in this slide, but statutory law can be brought into conflict with other statutory law. Because again, there isn't this built-in institutional process which demands logical consistency and coherence. Thus, statutory law does not share the inherent gradual and evolutionary properties of case law. Further, there is no analog to the stare decisis in the production of statutory law requiring coherence. Of course, I said that already. Legislatures are free to pass laws that are not consistent with existing law, and often actually do so. Statutory law can change abruptly and is therefore more beholden to the political and democratic forces. So you have, there's a greater dynamism, there's greater chance for a radical change in statutory law than there is in stare decisis. Again, it's not bound by this idea of a commitment to past tradition. This inevitably leads to tensions between two competing goods, the reliability and predictability, and presumably efficiency, via case law. Remember, one of the Supreme Court stated virtues of stare decisis is that it affords predictability and clarity, right? So that's a good. But on the other hand, statutory law is more responsive. So another good would be the responsiveness of law to the will of the people through their elected legislative representatives via statutory law. And also perhaps the need for immediacy of a set of policies to govern some new crisis or some new situation, again, environmental or social, etc. Sometimes inconsistencies have to be worked out at the level of the appellate court system. Note another distinction between the two courses of law. The application of a statute relies less on inductive reasoning, requires analogical reasoning, as in case law, and more on deductive reasoning in the sense of capturing a particular case under a general rule. This is something I mentioned a moment ago. So if the statute states no confession secured without the accused having been advised the Miranda rights is admissible in court, And it is the case that the current confession under consideration was indeed procured from the defendant without having been informed the Miranda rights, then it follows deductively that this confession is inadmissible in court. Right? So that's not inductive reasoning, that's deductive reasoning. Note, we could state this as a syllogism. All unmirandized confessions are inadmissible confessions. This confession is an unmirandized confession. Therefore, this confession is an inadmissible confession. Strictly speaking, while this is a categorical syllogism, it's not in standard form. So if I were going to be picky about it, go back to my notes on standard form categorical syllogisms, I'd have to clean it up a bit. Okay, now interpreting and applying the law. This is another sort of version of what is the law. So in order to determine what the law is, and for that matter, what the law should be, we have to know how to interpret and apply it. So what should the law be might be thought of in the broad philosophical sense, or what is the law might be thought of in a more narrow, specific sense. Typically, jurists and practicing attorneys are more interested in the second of these two questions. What is the law operating here in this situation? What is the legal issues at hand? Now, legal philosophers and constitutional scholars might be more interested in the first of these. What should the law be? For instance, while existing law may de facto sanction separate but equal segregated education systems, one might argue on both legal and philosophical grounds that that is not what the law is, or at least not what the law should be. We're going to talk about this a little bit later near the end, where we talk about the difference between natural law theory and legal positivism. But under the natural law theory, this can be captured in the idea of lex injusta, I think, non est lex, which is, an unjust law is not a law. And so the idea is that, well, if that's not really just, then it's not really the law. Right? It may have been passed by a certain legal body or something like that. Now, this is something that St. Augustine and St. Aquinas had argued when they would write on law and politics. It's also something that Thoreau talks about when he's defending civil disobedience, something Dr. Martin Luther King Jr. references in his letter to from a Birmingham jail. We'll talk more about that later. But again, this is a sort of broadly philosophical or perhaps constitutional law kind of question. But for the everyday practicing attorney, of more immediate concern is often determining which or what existing case law and statutory law is applicable to the legal situation at hand. This requires determining what facts are relevant to the resolution. We have to examine the facts of the case in order to determine what other cases might be relevant or what statutes might apply. Determination of case law for a particular case is a process that begins with research. Research analysis, identifying previous relevant cases, extraction of statements and of sentences passed and of previous decisions, and perhaps decisions of higher courts overruling lower courts in earlier cases, etc., to finally determine what all the applicable cases are and what is the most appropriate resolution to the one before us now. Statutory law is actually a little easier in that the statute is already written, and it's just a matter of finding what statutes apply to the facts in this particular case. But there are further questions when it comes to, well, what is the law? And what the law should be? But I don't necessarily mean in the broad philosophical sense. I mean, how should this given law be understood or applied? What is the law, or at least what was the intended purpose of this law? How should this law be interpreted? These questions may appear different and somewhat easier than the question, what should the law be in the grand philosophical sense? But they still can be very complicated, and answering them often turns on assumptions about what the law should be, though perhaps to a more narrow and pragmatic sense. That's very general. Let me be much more specific, right? Take a law that outlaws motorized vehicles in a public park. Well, would such a law outlaw motorized scooters like those used by people with mobility issues, right? Individuals who have a motorized, not necessarily wheelchair, but like a scooter, like you may see at, I don't know, Publix or Target or that sort of thing. Certain shoppers with mobility issues might use those to get around, etc. And if you were to use such a vehicle in the park, would that violate the law? Is it a motorized vehicle? What about regular motorized scooters? What about electric bikes or bikes in general? And what would distinguish one sort of motorized scooter from another sort of motorized scooter, if we want to say these but not those? So what is the law here, right? As so often occurs, the trouble is caused by vague verbiage. And of course, one of the very first topics we started looking at in this course was vagueness, ambiguity, and the trouble that can cause in critical thinking and clear thinking. Nevertheless, try as we may, sometimes it is impossible to rid our talk entirely of troublesome vagueness. Thus, interpreting and applying the law and determining what the law is will require the application of precising definitions guided by assumptions about what the law should be. And so we talked a little bit about that already when we talked about definitions. Again, a similar example. Let us suppose that a city ordinance forbids vehicles on the path in a city park. Clearly, a person violates that law if he or she drives a truck or a car down the path. But again, what about a motorbike or a bicycle, a go-kart, a child's pedal car? Just what counts as a vehicle and what doesn't, right? What about if you're driving an electric bike, but you're not actually using it electrically, you're actually pedaling it? Does that count? Right? This is the kind of issue that must often be decided in court because, not surprisingly, the government body writing the statute law could not foresee all possible items that might, in somebody's mind, count as a vehicle. There was once a law in New Hampshire which made it illegal to excrete bodily fluids in public. Without realizing it, they had criminalized sweating in public, at least under a certain interpretation, perhaps crying as well, excretion of a body fluid. The process of narrowing down when the law applies and when it does not then is another kind of reasoning task that occurs in connection with law. A less amusing example would be stand your ground laws. More than half of the states in the United States have adopted something called the Castle Doctrine. This is the legal position that a person does not have a legal obligation to retreat from a threat in his or her own home. And further, that the person may use deadly force in order to thwart an attacker in such circumstances. So according to the Castle Doctrine, if one is in one's own home and there is, let's say, an intruder, even if you have the ability to flee, you do not have an obligation to retreat, and you may respond to that intruder, if that intruder is threatening your life, with deadly force. Right? Again, this is called the Castle Doctrine. In Florida, as in several other states, a further law was passed in 2005 that removed the obligation to retreat and extended the right to use deadly force in self-defense to any place that the defender had a legal right to be. So it says, okay, you don't have to retreat from a deadly threat. You don't have a legal obligation to retreat from a deadly threat in your own home or any place you have a legal right to be. So that's an extension. Oh, by the way, I think even the Castle Doctrine, I think, covers your car. So your house or your car, I think. I'm not a lawyer. I don't even play one on TV, but I think that's the case. But the Stand Your Ground law expanded it beyond your home and even your car. It's just any place you have a legal right to be. Such laws have come to be known as Stand Your Ground laws. Now, whether the Stand Your Ground laws have reduced or increased violence is not clear. Proponents and opponents have both cited evidence, and there may have been studies that interested parties can check before making up their minds. That's not the point of my remarks here. But this law came into sharp focus in February 2012 when George Zimmerman, a 28-year-old multiracial Hispanic, shot and killed Trayvon Martin, a 17-year-old Black youth, during a much disputed confrontation. Martin was walking home from a convenience store to the house where his father's fiancée lived and where Martin was staying. Zimmerman, the neighborhood watch coordinator, was in his vehicle when he spotted Martin, and he called police to report him as behaving suspiciously. Zimmerman left his car during the call, and soon after a violent encounter ensued, the only account of which is Zimmerman's, since Martin was shot dead in the fight. Zimmerman claimed Martin, who was unarmed, attacked him, and that Zimmerman had fired his weapon in self-defense. The Sanford police were subjected to criticism for delaying bringing charges against Zimmerman, the shooter. The cause of the delay, according to the police and local prosecutors, was the Stand Your Ground law, which provides not only a legal defense in a criminal trial, but it also provides immunity from civil suits and from criminal trial under the right circumstances. So in other words, they weren't sure whether they had grounds to charge Zimmerman, at least at this point, and this is why they delayed, because they thought, oh, this might be a case of a stand your ground situation. In other words, we might have to apply that rule to this situation. Eventually, Zimmerman did go to trial in June 2013 on charges of second-degree murder and manslaughter. On July 13th, 2013, a jury acquitted him of both charges. It is worth noting that although Florida's Stand Your Ground law was clearly relevant to the case, Zimmerman's lawyers made scant reference to it during their defense. The extent to which it influenced the jury is not known. Moving to another topic now, forms of legal reasoning, interpretation, and application of legal rules. Step 1, read and determine the structure of the applicable legal rules. So if we're going to be interpreting and applying legal rules, we want to be clear on what the structure is. Laws can be written in a way that makes them difficult to understand. Interpretation of the text of a law requires a systematic approach. Legal rules have a fundamental if-then structure. Of course, we're quite familiar now, at least we should be, with the conditional if P, then Q, right? That's the conditional structure. If P is the antecedent, then Q is the consequent. Right? And rules are written with this kind of conditional structure. If the facts of the case satisfy a set of criteria, the elements outlawed in the rule, then the law imposes consequences, the results. So if the elements, then the results. If the elements obtain, then the results are to be applied. So identify the elements. Step 2 then, identify the elements of the rule. The elements of the rule can come in different formats. First, some kinds of legal rules have conjunctive requirements. Here, the antecedent of the conditional of list of elements, each and every one of which must be satisfied before the consequent result. The easiest way to identify a conjunction test is to look for the word and. So here's an example from civil code. A valid contract is a lawful contract which is 1, I put in the numbers, concluded by parties of full capacity, and 2, has an object susceptible of its legal consequences, and 3, its attributes are valid, proper, free from any defects. Now, without going into the semantics, in other words, without going into what these elements mean, we can look at the syntax. And the syntax here shows us that this is a conjunction, which says the 3 elements, 1, 2, and 3, all must be met in order for the contract to be considered lawful. Note this rule specifies 3 elements, all of which must be met in order for the contract to be deemed lawful. This is a formal syntactic requirement. It may remain a question as to what is precisely meant by free of any defects, right? So the semantics may still need to be worked out here, but the syntactic requirement is this conjunction of the three items. Consider some of the topics we covered when looking at definitions. If you think back to when we talked about necessary and sufficient conditions, etc., and how definitions provide us with necessary and sufficient conditions. Some definitions do. So if I gave you a definition of a square, for instance, I might cite the following conditions: a closed plane figure, having four equal sides, having four 90-degree angles. This would be an example of a conjunctive requirement. Note that each of these elements is necessary, and they are jointly sufficient. Absent any one, and the object is not a square. So it might be a closed plane figure, and it might have four equal sides, but if it doesn't have four 90-degree angles, it's not a square. Maybe it's a diamond or something like that, right? Okay. A second kind of structure to the elements might be disjunctive requirements. The antecedent lists multiple elements, but only one of those elements must be satisfied before the consequent result. Again, the test word for a disjunction would be or, right? A or B or C, right? So here's an example. Any person who accidentally kills another without premeditation or causes him to be killed without premeditation, so that it is the result of negligence, thoughtlessness, lack of due care and attention, or lack of regard for any law, regulation, or decree, is punishable by detention plus a fine, or by one of those penalties. So the antecedent lists multiple elements, but only one of those elements must be satisfied before the consequent result. But note the consequence itself is a disjunction. It said that if any one of the antecedent elements is satisfied, then the consequent to follow is either detention or a fine, or both detention and a fine. So this brings us to what's called sometimes multi-factor elements. This rule establishes a multi-factor test, laying out several criteria, any one of which will trigger the application of the rule. Thus, it requires a decision maker to consider each of the criteria. Unlike the conjunctive test, the absence of one element is not enough to invalidate the application of the rule. But since the consequent, the application of the rule, itself refers to a range of options, the application of the rule requires discretion in determining the significance or weight that should be assigned to each of the elements of the antecedent. Right? So why are there a range of options? A fine, incarceration, or fine and incarceration, right? Well, because there might be other things to consider, other things to weigh, and that actually gets us to the third criterion that we have to look at when identifying the elements of a rule: balancing requirements. Sometimes rules have implied balancing requirements, as I think the previous one did. Sometimes they're actually quite explicit. Thus, sometimes rules contain explicit balancing element, which acts as a qualifier on the application of the rule. A balancing test refers to the need for the decision maker to weigh competing values or factors against each other and determines which factor is more important to applying the rule. So an example might be this: if there exists any aggravating circumstances in conjunction with mitigating excuses or circumstances which call for leniency, the court shall take into consideration firstly the aggravating circumstances, then the mitigating excuses, then finally those circumstances which call for leniency. So in other words, these are all qualifications for the application of the rule. And we can see how these might play into, for instance, when it's a disjunctive consequent, fine, imprisonment, or fine and imprisonment, where these might be used to help us figure out which of those three of the disjuncts we should adopt. And then finally, 4, rule exception requirements. Rules might also include elements which provide exceptions or factual circumstances specifically removed from the consequences of law. Factual circumstances specifically removed from the consequences of the law. So the right of the legal defense does not permit any person to resist a member of the public authorities in the execution of his duties, even though he has overstepped the bounds of that duty while acting in good faith, unless it is reasonably feared that death or serious injury will result. So that's the exception. So you can resist a member of the public authorities in the execution of his duties if it can be reasonably feared that death or serious injury will result. Now, of course, raises an interesting question, reasonably feared. And we talked back when we were looking very briefly, we spoke about ideal observer theory. And what does it mean to say that someone has, this was when we did the module on aesthetic reasoning and specifically theories of beauty. And we talked about ideal observer theory as one way of trying to make out what it means to say that something is beautiful. Well, to say it's beautiful is to say ideally situated judges would find it pleasing or something like that. Well, what does it mean to say something is reasonable? Notice the very notion of the reasonable person or beyond a reasonable doubt, or that this might be reasonably feared, is a kind of ideal observer theory mechanism. Would a reasonable person have feared for his life under these circumstances? Would a reasonable juror have doubts after having canvassed all of the evidence, etc.? Step 3, so we did step 1, made clear. Step 2, look at the elements. Step 3, analyze the structure of the rule results. Results can be divided into 4 different categories. Results can be mandatory when they require an action. Results are prohibitory when they forbid an action. Results are discretionary when they empower the government official to exercise their judgment on whether or not to take a particular action, right? Like in balancing situations or exception situations. And then the fourth, results are declaratory when they simply state what is and is not legal. In general, the key is to develop, in general, the key skill to develop is to learn how to break a legal rule into smaller pieces and to understand its logical structure and determine if and how it applies to the facts in the particular case. Again, are the elements met, that sort of thing. So 5 types of legal reasoning once a legal rule has been analyzed. So now we've analyzed our legal rule. What are certain ways that we proceed going forward? Right? Once the structure of the legal rule has been analyzed, one can then deploy forms of legal reasoning to interpret its meaning. There are principally 5 types of legal reasoning involved: rules, analogies, policies, principles, and customs. Rules, probably the most straightforward. Rule-based reasoning relies on the use of syllogisms or arguments based on formal logic. Right? No unmirandized confessions are admissible. This was an unmirandized confession, therefore this unmirandized confession is inadmissible. Right? Analogical reasoning, of course, we've spoken about that quite a bit today, but it compares or contrasts the facts of a yet to be decided case with the facts of previously decided cases and argues that the current case should be decided in a manner similar to, or perhaps different from, the previous case. This type of reasoning often involves the use of prior judicial decisions. But we haven't talked about this then, deciding cases with a reference to policy. policy reasoning argues for a particular interpretation of a legal rule because it would result in sound public policy. In other words, it's in the best of interest of the public to interpret this rule in this way as a general rule, right? This will result in the best outcome for society at large, not just the parties in the dispute. So again, the idea is that by deciding this case in a particular way, we're not only having immediate effects on the case before us, but we're establishing precedent going forward. And so we want to take into account, is this a good policy to establish? An argument from public policy might claim that a particular outcome would promote the efficient, fair, and predictable operation of the courts. It might be based on institutional competence, or the idea that decisions should be left to a particular branch of government exclusively. Well, this should be left to the executive branch, the judicial branch, the legislative branch, or that the skills and the expertise is best handled in this way because this institution or this body has the best skills to resolve the dispute in the interest of the public. Public policy may also rely on economic reasoning, arguing that one outcome would promote economic growth, efficient resource allocation, or appropriate balancing of cost to benefits better than some other outcome. So again, policy is sort of a consequentialist notion. What interpretation would be a good policy to follow? What way of interpreting this rule is going to have the best consequences for society at large? Arguments from principle. Arguments from principle draw on common social values such as morality, justice, fairness, equality, democracy, personal freedom, etc. Given an historic commitment by society at large to a particular principle, it can be argued that the resolution most in accord with this principle is the preferred or the correct one. So here what you might argue is interpreting the rule, interpreting the policy, interpreting the statute in a particular way is most in accord with established principles to which society has long been committed. And that's another way of interpreting a line of argument for interpreting a rule. And then finally, lawyers may argue that a law should be interpreted so as not to conflict with social custom. So this was probably more utilized in the past than I think contemporarily. Notice we live in an increasingly culturally diverse, pluralistic society. And so this sort of appeal becomes inversely effective because there may not be widely adhered to or acknowledged social customs. There may in fact be competing social customs. And so it's a little more difficult for this kind of argument to get traction today than when in a more homogeneous society. Nevertheless, it still is done. Legal reasoning about cause and effect. Also especially important when it comes to applying the law is careful reasoning about cause and effect. Causation is the foundation for legal liability. In some contexts, that a party is legally liable for something may mean more than simply that he or she caused it. But having caused it is normally considered a necessary condition for being legally liable for it. You may want to revisit my notes on last proximate cause from our module on causal reasoning, because I talked a little bit about that there. But notice if I'm a gas station attendant who sells gas to a driver who has run out of gas, and but it turns out he is drunk, and so he uses the gas I sold him to get his car started and then gets into an accident. Am I responsible for that? There's a sense in which, but for me selling him the gas, that accident wouldn't have occurred. On the other hand, is it appropriate to say I'm the cause of the accident? The minimum requirement, the but for requirement, might be met, but there might be more proximate causes that stand in between me and the accident. But then beyond that, Could it have been reasonably foreseen, etc.? Hold on now. Let me stop sharing just for a moment and let me pause. There we are. Okay, sorry about that. Got a phone call. Oh, cause and effect. So we talked about last proximate cause, a legal liability, determining what the cause of a particular event is, like a car accident or something like that. And so you may want to review those notes. Now, when it comes to justifying laws, what would recommend us enacting a law or having a particular law on the books, etc.? And there are four main perspectives that have often been given in terms of trying to justify a law. The reasoning employed to justify or defend specific laws is similar to moral reasoning. Both types of reasoning involve applying general principles to specific cases, and both refer ultimately to one or more of a handful of basic perspectives within which the reasoning is taking place. Indeed, moral perspectives already discussed, think about our module on ethical reasoning, can and are used to justify and defend specific laws. For example, the utilitarian idea that it is desirable to increase the sum total of happiness is used to defend eminent domain, by which a state seizes a person's privately held property without his consent. So if the state determines that it has to put a highway through a particular area for the greater community good, it is allowed to basically seize the property under eminent domain of individuals. They have to compensate the individual at market rates or something like that. At least that's so technically how it's supposed to go. But notice it doesn't have to be with the consent of the person who actually owns the property. So notice the deontological principle that others should not be deprived of their private property and thus used as mere means to some end has been used against that same practice of eminent domain. So again, we have a moral reasoning of consequentialist utilitarianism, of course, another moral reasoning of deontological respect for individual rights. And as we mentioned in our module on ethical reasoning, consequentialist thinking and deontological thinking often run into conflict with one another. And they can both recommend a particular legal practice, or they might criticize a legal practice, as with eminent domain. The harm principle, which we'll discuss below, holds that only what harms others should be legally forbidden. It is an extension of the deontological ethics with its commitment to personal autonomy and individual liberty. Ironically, though, its most eloquent exponent was a consequentialist thinker, John Stuart Mill, who defends rights, again, a deontological notion, but he defends rights on consequentialist grounds. And if you're interested, you should read his essay on liberty, where he does just that. Of course, we are most often interested in the justification of laws that would forbid us to do something we might otherwise want to do, or require us to do something we would prefer not to do. Consider then whether a law that forbids doing X should be enacted by your state legislature. Typically, there are four main grounds or perspectives on which a supporter of a law can base his or her justification. First is simply that doing X is immoral. The claim that a law should make illegal anything which is immoral is the basis for a position known as legal moralism. Now, legal moralism can be seen as a kind of absolute, anything that's immoral should be illegal, or a more modest version would be only seriously immoral things should be made illegal. So for instance, I think it is immoral to gratuitously insult someone, right? Just to say nasty things to them. Well, you know, you're overweight and your hair doesn't look good and I hate that outfit. Well, I think that's immoral. but I don't want to make it illegal. I don't think there's anything, I think that would be overreach, right? So that kind of absolute legal moralism, I think, is unreasonable. And I think even people who are warm to the idea of legal moralism would agree with that, that it's really the serious moral infractions that perhaps we want to make illegal. One might use a basis to justify laws forbidding murder or assault or licentious sexual practices. Notice, the idea of international crimes against humanity. Want to say that sometimes the grievousness of the morality is such that it calls for them us to consider them to be illegal. Again, a kind of violation of international law, even when it isn't necessarily a codified international law. For legal moralist, arguments designed to show that an action should be illegal are directly tied to the claim that the action is, in fact, immoral and perhaps grievously or seriously immoral. A second ground on which a law can be justified, the harm principle, is probably the one that most people think of first, at least contemporary Americans, right? And it's very closely associated with John Stuart Mill, the aforementioned utilitarian and consequentialist moral thinker, who was also a legal reformer, by the way. Mill held that the only legitimate basis for legally forbidding X is that doing X causes harm to others. Notice that the harm principle states not just that harm to others is a good ground for forbidding an activity, but that it is the only grounds for forbidding such an activity. Note further that if the act is harmful, but only to the person or persons consenting to the act, then this is not considered sufficient grounds for legally forbidding the act. According to Mill's version of the harm principle, self-regarding behaviors are not thought to be justly regulated by law. Self-regarding meaning behaviors which affect no one other than the person engaging in the behavior. But as we noted when we examined consequentialist ethical reasoning in the module on ethical reasoning, the consequentialist is making an empirical claim about what results from tolerating or from forbidding a particular behavior. This cannot be idle speculation, but rather these claims need be grounded in objective fact. Because notice you're making an empirical claim, a scientific claim about forbidding a behavior having certain consequences or permitting a behavior having other consequences. Well, how do I know, right? You can't just speculate. You have to have evidence for this. A person who defends or criticizes a law based on this principle must present convincing evidence that doing X does indeed cause the serious harm to others that is alleged. So, for instance, often pornography has been censored on the basis that proliferation of pornography does harm to society. Sometimes more narrowly, it does harm to women, right? Well, it's not enough to speculate about that. You actually have to show what evidence there is, what empirical evidence there is to show that there's a very strong connection between permissive attitudes towards pornography and serious harm to women. A third ground on which our hypothetical law might be based is called legal paternalism. Legal paternalism is the view that laws can be justified if they prevent people from doing harm to themselves. That is, they forbid or make impossible to do X for that person's own good. Note this explicitly conflicts with Mill's version of the harm principle. Mill was an anti-paternalist. He didn't think the government had a right to run your private life, and the government didn't even have a right to prevent you from harming yourself. If you want to harm yourself, that is within your rights. This is what Mill thought, right? That's not what legal paternalism says. Legal paternalism says, no, this is a just reason why the government should restrict certain kinds of behaviors because they're harmful to the person engaged in those behaviors. Examples would be, for instance, laws which require us to wear seatbelts while riding in automobiles, or laws that require us to wear helmets when riding on motorcycles, etc. Right? So whom am I endangering when I don't wear a seatbelt? Well, really just me, right? Now notice, is it a good idea to wear a seatbelt? Yes, it is. Take my word for it, right? It's a very good idea to wear a seatbelt. But is it the government's responsibility to restrict your individual freedom for your own good or not? Legal paternalists say yes, at least sometimes. Harm principle, John Stuart Mill thinkers, no, that isn't. Right? So it's an interesting legal and philosophical debate. But notice many laws prohibiting or limiting the use of drugs also fall into this category. Quick story, I remember back in the 70s, I was a young man at that time, and there was a drug called Laetrile, I think that was the name, and it was some sort of derivative of peach pits. And it was offered as a kind of cancer treatment. Now, it had no good effects. It did not cure cancer. It did not treat cancer. It did not mitigate the effects of cancer. It had no positive effects whatsoever. But it had no negative effects either. It wasn't a hallucinogen. It wasn't a narcotic or anything like that. It just was inert for the most part. But the Food and Drug Administration ended up making it a banned substance. And not because they thought that it was harmful in and of itself, but they thought that people taking it might forego more reliable and useful, salutary cancer treatments. And they're taking this fake drug instead of taking the real thing. So it's like, look, people might be too ill-informed or too irrational or too stupid to do what's good for them. And they may end up taking this useless drug, and we're not going to allow them to do it. We're going to forbid it. Right? Well, that's clearly an example of legal paternalism. Right? The fourth of the usual basis for justifying criminal laws is that some behavior is generally found to be very offensive. The offense principle says that a law forbidding X can be justified if X causes great offense to others. Laws forbidding public urination, for instance, or public nudity or public sex acts are often justified on this grounds. Note here that the claim is not that the behavior in question violates moral norms or moral rules, but rather that it's seen as offensive. There may in fact be nothing immoral about urinating in public, but we might want to prohibit it because many people simply find it offensive. Right? So notice this kind of piggybacks onto a brief conversation we had when we were doing aesthetic reasoning. And remember on the lecture on beauty and theories about what it means to say something is beautiful. Well, I opened those notes by looking at what it means to say something is obscene, and we might read here offensive, right? So we covered in those notes the notion of the ideal observer theory. And the idea is that to say something is offensive is to say that it's such as to cause offense to normal, sensitive, informed, and unbiased persons. But we employ the ideal observer theory all the time in notions of obscenity. I think sometimes in notions of what it means to say something is beautiful. I think in notions of what it means to say something is sexual harassment, etc. But the problem, I think the very notion of, I think maybe I mentioned this already, but the very notion of beyond a reasonable doubt is an ideal observer theory mechanism, right? Would a reasonable person have a doubt after having canvassed all of the evidence presented, right? Despite the fact that the ideal observer theory is used all the time, it does run problematic when you ask yourself, well, how old is the ideal observer? What gender is the ideal observer? What sexual orientation is the ideal observer? What religious background does the ideal observer have? And if you say, oh, none of that matters, really? Because what you find offensive may have a great deal to do with how old you are, what sexual orientation you are, what religious background you have, etc. And if you say, well, anybody who has preferences based on those things, we won't consider them an ideal observer. Then who's left, right? Who is it that has no preferences based on anything such as the history of the person that they are, what they brought to this moment in time? Right? So anyway, I'm a bit off. But I think I say this here. This is closely related to the notion of obscenity and laws governing obscene materials and acts. Recall, we briefly considered the challenges of establishing what is and is not obscene in the notes on beauty in the module on aesthetic reasoning. We have more or less adopted the ideal observer theory regarding matters of obscenity. If you review the notes there, you'll see the Miller test, for instance. But employing the ideal observer theory always brings with it a question of who is the ideal observer, how old, what gender, what sexual orientation, what religion, etc. Reasoning before a judge and or a jury in general. Now, it's clear that neither jurors nor judges will be led to agree with you and to accept your position as firmly established by simply you telling them that you would very much like them to believe it. Neither can you succeed in convincing them by telling them that they should believe it, and they should believe as you wish them to believe. The critical audience will not be cajoled or browbeaten into belief. How then are you to persuade? I had a colleague years ago who reminded me that the first rule of rhetoric is know your audience. The only method to persuade your audience is to give them what they demand, reasons. This will require clearly stating what the issue is and why your answer to that question, to that issue, is the correct one. So first, you have to establish the issue and clearly distinguish it, or them, if there's more than one, from distractions. In other words, what is not the issue, lest they be led astray by red herrings. Then you establish what facts will logically compel the judge or the jury to adopt your position, and then you present them with those facts which prove your resolution to the issue is the correct one. Naturally, the reasons you give to support your conclusion will not be effective unless they are reasons that the audience does or will believe. And how are you to know what reasons your audience will believe? Well, consider, why do we ourselves believe those things we do accept? We believe that which most accords with our own past experience. That is, those things which in our experience we have always found to be true. We are unwilling to believe something which is inconsistent with our past experience, or even to accept a new belief which we did not previously accept and are agnostic about. So I don't know if there's life on other planets. I don't positively disbelieve it, but I don't believe it either. And so it's not a belief that's in my wheelhouse. It's not part of my stock. It's not in my pantry, as they say, right? And so if you're appealing to a belief that I'm agnostic about, I'm not going to necessarily find your argument very convincing, right? Because one of your premises is something that I don't necessarily accept. And of course, if I positively think that the premises you're using are false, well, then your argument is going to be even less convincing. Of course, there are other things that we believe, although we have not experienced them directly, but we accept the testimony of others. We believe that Columbus visited America in 1492, that Ulysses S. Grant was a great general, that George Washington was our first president. These things have not been experienced by us directly, but indirectly. Others within whose experience these things have fallen have led us to accept them as so, and so thoroughly that they have become part of our experience kind of secondhand. We're sort of epistemically dependent beliefs. This is similarly true for sources of information. We are more likely to believe reports from individuals or news sources we have previously found to be accurate and trustworthy, and to resist accepting accounts for sources we have previously deemed to be suspect or inaccurate. Sometimes the conclusion cannot be supported by reasons that come from within our experience, in the experience of the audience. In that case, it's necessary to support that by other reasons that do come within the experience of the audience. Hence, know your audience. You must find the common ground between you and them, and then build out from there. You have to meet them where they already are, and then build that bridge to where you want them to be. Remember then that the goal must be to show them that the proposition you propose, by the standard of their own experience, is correct. Many attempts have been made to put evidence into different classes and to give objective tests of good evidence. However, the overriding concern one must be mindful of in judging the power of the evidence is whether it will be effective in the target audience. Will it be convincing to them? In other words, will it make their own experience quickly and strongly support the issue? So, what reasons are those the audience will believe? They will believe those statements which harmonize with their own experience and will discredit those which are at variance with their own experience. And this experience, as we have seen, may be firsthand or direct, or it may be indirect and secondhand, but from trusted sources. Thus, the successful speaker must base the argument upon reasons the hearers believe because of their own direct or indirect experience. Suppose I assert John Quinn is a dangerous man. Someone says, prove that statement. I say, well, he's a violent thief. Someone else says, well, if that's true, then he is a bad, violent man, dangerous. But can you prove that he was a violent thief? Then I produce a copy of a court record, which states that on a certain day, a duly constituted court found John Quinn guilty of armed robbery of a bank. All my hearers likely will now admit not only that he was a thief, but that he was also a dangerous man. I have given them a reason to accept my conclusion and a further reason to accept that reason, until at last I have shown them that my assertion, John Quinn is a dangerous citizen, rests on what they themselves already believe. To that same notion, legal reasoning and witness testimony. In courts of law where witnesses appear and testify as to events as they did or did not occur, it is necessary that the jury be able to distinguish carefully between what it should and should not believe from these witnesses. Witnesses often have personal interests in the verdict and therefore may be inclined to tell less or more than the truth. Sometimes witnesses are relatives of the person who will suffer if the case were decided against them, or they would therefore have incentive to give biased testimony for that reason or some other reason. In order that the jury may decide as fairly as possible what witness testimony is to be trusted and to what extent, attorneys on each side of the case make out a copy of what are called instructions. These are given to the judge who, provided the judge approves, reads them to the jury. Usually these instructions urge the jury to consider four things. First, they must consider whether or not the statements of the witness are probable. That is the account provided by the witness consistent with human experience? Does it seem natural or reasonable? Second, they are told to bear in mind the opportunity the witness had in observing the facts to which the witness has testified. Was the witness in a position to be familiar with the things as described? The jury should consider the physical and mental qualities of the witness with respect to the testimony. Is the witness a person who is physically and mentally able to judge what the witness testifies to have observed under the known circumstances? So if the witness is known to be very nearsighted and yet claims to have identified the assailant at a great distance, then we might take that into account. Wait a minute, how could that witness have seen what the witness testifies to have seen when they have limited visual abilities? A third factor is the possibility of prejudice on the part of the witness. Does the witness have any reason to feel more favorably towards one side than towards another? Is the defendant a friend or a relative of the or employer, or perhaps someone with an axe to grind against the accused? And the final consideration is what is commonly called interest in the case. If a witness will be benefited by a certain verdict or harmed by a specific verdict, the witness may frame evidence and testimony in such a way that will tend towards the desired verdict. So these are things to consider when weighing witness testimony, and these are instructions often given to jurors. All these considerations are based on the general rule of referring to experience. What a judge really says in the charge to the jury is this: does your experience warn you that the testimony of some of these witnesses is unsound? Determine upon that basis in what respects these witnesses have told you the whole truth and in what respect they have not. To summarize then, the conclusion is to be proved by the supported evidence, by being supported with evidence, since evidence is the material with which we build the connection between the conclusions and the experience of the audience. That evidence will be best, which will receive the quickest and strongest support from the experience of the hearers. All these considerations are based on the general rule of referring to experience. What a judge is really saying in the charge to the jury is this. Oh, I've read this already. Sorry about that. And I read that already. Okay. Asking questions like a lawyer. Okay, I came across a YouTube video and I thought it was kind of interesting. And so that's where this comes from, right? This guy in his YouTube video, where he gives one secret and 3 tips about asking questions like a lawyer. So his one secret is this: he himself is a lawyer. Lawyers, when acting like lawyers, he has in mind, are not really asking questions. We're actually making statements that sound like questions. Here, we ask questions that the witness must agree with or somehow look silly. People generally try to avoid things that they believe cause them pain, don't they? Am I asking that because I'm really curious? No, I'm putting the witness in a position where either they can agree, yes, you're absolutely right, or they could try to weasel out if for some reason or another they want to do that. But if they do that and they say something like, well, I don't know, well, maybe some people like pain or something like that, well, they will immediately lose credibility with the jury or the judge. And therefore, the point of the question was not really to ask a question, but it was to possibly damage the credibility of this particular witness. Now, the rules. Have goals. First of all, lawyers ask questions with a particular goal in mind. They are not seeking information so much as they are asking a question in order to make a point or establish a position. For this reason, it is prudent to avoid open questions that allow the witness to speculate or digress or change the subject. Best to ask targeted questions designed specifically for achieving the goal that one has in mind. For instance, if you wish to establish the point that the witness has no alibi, say, corresponding to the time of the crime was committed, first you would want to know in advance that the witness in fact has no alibi. So again, if you know in advance the witness has no alibi, you may then want to go and ask the witness about the alibi. Then you would ask, where was the witness? Or what was he doing at the time of the crime? You would follow that up with whether or not anyone can corroborate the account that the witness has provided. You might then further direct the court's attention to the fact that there is evidence which contradicts the witness's testimony about his whereabouts during the time of the crime. In short, the lawyer is not asking the question, where were you at the time of the crime, because he's curious. The question is targeted to establish the point or getting testimony in evidence that could later be impugned. Second tip, lawyers tend to ask leading questions. There is an old adage that a lawyer should never ask a question to which the lawyer does not already know what the answer is, or at least know what answer the witness is most likely to give. So you might ask, you argued with your neighbor about his mailbox in the past, haven't you? And on those occasions, you claimed that his mailbox was on your property. Isn't that the case? And on some of those occasions, you threatened to knock down his mailbox if he did not remove it, didn't you? And can you explain how it came to be that your neighbor's mailbox was subsequently knocked down? So again, if I'm the lawyer asking these questions, presumably I know the answer to all of these. I know that the answer is yes, 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 and I don't have an explanation. That's going to make you look very suspicious in the eyes of the jury, or at least that's my intention. And then rule number 3, keep questions short and limited and to one fact. Again, you want to control the witness. So you want to avoid compound questions. So notice, were I to ask a witness, are you the contractor who purchased the sledgehammer at Home Depot on Thursday morning? Well, what if the witness responds no? Well, I don't know what he's denying, right? He's not a contractor. He didn't purchase a sledgehammer. Didn't go to Home Depot. It wasn't Thursday morning. He might be denying any one of those, or he might be denying all of those, or any combination, right? So you want to not have a complex question. You want to have a simple, a targeted question. This is why you need to confine yourself to simple questions which are not compound. So you might start by saying, you are a contractor, aren't you? And then, did you purchase a sledgehammer recently? And then, final topic for this, which is natural law versus legal positivism. Natural law and legal positivism are two schools of thought that have opposing views on the connection between law and morals. Natural law holds the view that law should reflect moral reasoning and should be based on moral order. Lex justa, I'm saying it wrong, known as lex, but an unjust law is not a law. Legal positivism holds that there is no necessary connection between law and morality, and that whether a law is legitimate is a matter of whether it was arrived at according to the proper legal processes. Thus, these opposing views on the law, on the nature of law, differ as to whether or not the law is a sort of mind-independent thing that we discover and perhaps come to a more and more adequate understanding of, and that our own laws should seek to approximate. So we should approximate the law, right? And where our laws fail to meet the justice, the law, they aren't real laws, or they're flawed. Or whether law is an entirely socially constructed affair with no court of higher appeal, so to speak, right? So if we say it's the law, it's the law. As long as we did the right steps and we did it in the right order and it conformed to the right legal processes, it is de facto the law. Note, this is similar to the dispute between realists and essentialists and nominalists with respect to natural kinds, which we discussed in our review of definitions. So you might, if you're interested, go back and look at when we talked about realism and nominalism and natural kinds. And our natural kinds, things we discover, right? We discover the necessary and sufficient conditions of, let's say, what it is to be a cat, or did we discover that whales are not fish, in fact, they're mammals? Or is it a social linguistic feature that we simply use common nouns in particular ways, and we have a sorting convention, and the sorting convention is basically decided by the way we choose to use our common nouns like cat and fish and whale. Again, in the case of natural law and legal positivism, the dispute is whether we discover the law, like natural kinds, or is the law, like common nouns that are, as the nominalists would have us believe, merely fixed by social linguistic convention, guided only by our social forces and pragmatic considerations. For instance, is marriage a natural kind which we must discover, and natural law must acknowledge, or is it wholly a social convention, subject to modification and legal definition and redefinition? Likewise, consider end-of-life questions and law governing, say, organ harvesting from terminally ill organ donors, for instance. Is there a definition of death which we must discover so as to do adequate justice to the sanctity of the human life, such that if this terminally ill organ donor, if I were to harvest his organs prematurely, I would be killing someone who wasn't quite dead? Or is the question of death something to be decided on pragmatic grounds, such that certain definitions are more useful in certain circumstances than others? We do have different standards of death when it comes to biomedical issues, etc. One standard basically says when your heart stops, you're technically dead. And some have argued that no, that's not sufficient. It's not only your heart has to stop, but your heart and respiration and the cessation of brain waves. Right? So again, is it something to be defined and perhaps guided by pragmatic values and useful social policy, or is it something to be discovered? According to natural law theorists, natural laws derive their validity from morality and reason, and are based on what it is believed to serve the best interest of the human person and the common good. It is also important to note the moral standards that govern human behavior are derived to some extent from a commitment to an inherent human nature and the natural world. Again, note either a tacit or explicit commitment to realism or essentialism. In other words, if natural law is grounded in human flourishing, and if any notion of human flourishing is ultimately grounded in some idea that there is a fixed human nature, such that certain activities contribute to the flourishing of that nature and certain activities contribute to a diminishment of that nature, well, then natural law, which is grounded in human nature, is ultimately grounded in essentialism, that there is an essential nature to humans. In this perspective of natural law, good law is law that reflects this natural moral order through reason and experience. It is also important to understand the word moral here is not used in a religious sense, but it refers to the process of determining what is good and what is right based on reasoning and experience. The history of natural law can be traced back to ancient Greece. Philosophers such as Plato, Aristotle, Cicero, Aquinas, Gentili, Suarez, etc., have all used natural law in their concepts and their philosophies. Both Henry David Thoreau and Martin Luther King seem to adhere to this sort of understanding of law in their defenses of the propriety of civil disobedience as an appropriate response to unjust laws. By contrast, legal positivism is an analysis of law developed by legal thinkers such as Jeremy Bentham and John Austin. The theoretical foundations of this concept can be traced to modern developments of British empiricism and logical positivism, as more or less a deliverance of the Enlightenment thinking. Recall that the Enlightenment can be almost typified or characterized as a rejection of the classical worldview and the embrace of modern philosophy and modern science. And part of the things that identify modern philosophy and modern science is a rejection of things like essentialism and teleology, that there's a human nature or an end towards which all human beings are directed. So it's only natural that if you don't think there's a fixed human nature and you don't think there's a fixed sense of what constitutes human flourishing, then you're not going to think that there is a natural law which flows from those items. This is considered, by that I mean legal positivism is considered historically as opposing the theory of natural law. Legal positivism holds that the source of law and the sole legitimizer of law is the establishment of that law by some socially recognized legal authority. This is a disenchantment of law of sorts, consistent with modernist tendencies generally. It also includes the view that there is no necessary connection between law and moral judgments. Legal positivists consider a legitimate law as a law that is enacted by proper legal authorities following the rules, procedures, and constraints of that legal system. Proponents often maintain that moral judgments cannot be defended or established by rational argument and evidence. So they deny what the natural law theorists were claiming, that morality can be established by experience and evidence and argument. One might think of David Hume, who famously says one cannot validly deduce an ought from an is. According to David Hume, no amount of information about how the world is can tell us how the world ought to be, and no amount of information about how the world ought to be can tell us about how the world is, that there was a fact-value divide. And this is very much in keeping with modernist thinking, and again, British empiricism, logical positivism. You may want to revisit some of those notes there. So we can't ground law in a evidential, rational understanding of the world, because a rational, well, we can ground law in a rational and evidential understanding of the world, but not necessarily in a moral understanding of the world that it itself is rational and evidential. Hume, for instance, thought that morality is ultimately grounded in empathy and sympathy for our fellow human beings. So an emotional quality, not an evidential quality or a factual quality. Note then the different sorts of logic that result from these competing views on the nature of law. One suggests that law is something to be discovered and that there is an ideal to be strived for. And so the idea is you're looking for the truth, right? The other suggests that law is to be crafted as a pragmatic response to social problems. And so it's sort of the logic of creativity and creative solutions to moral and social and legal problems, rather than the discovery of a pre-existing truth. So I believe that's my last slide on this, and it is. So this concludes my remarks on legal reasoning. I hope you find them helpful. And naturally, if you have any questions or want to pursue some of these topics in greater detail or with greater clarity, please contact me. I'd be only too happy to discuss them with you.